There's been a lot out there talking about loan mods, and you've heard a lot about residential, and, let's go after the lenders and see if we can get them on truth in lending violations, rental violations, on and on and on. So, in order to get loan mods straightened out. Well, I'm going to go over to another area because there's a lot of case law on commercial loans and recourse, non-recourse loans, and we're going to see a lot more of that in the coming year. So I thought I'd talk a little bit about carve-outs and non-recourse loans. Over the last several years, of course, there have been a lot of commercial loans made on a non-recourse basis. Well, what is a non-recourse loan? It's a loan, non-recourse loan is where a lender looks to the property for recovery in case of default and foregoes a personal cause of action against the borrower. Now, to lessen the lender risk, such loans are going to include a variety of guarantees and indemnities given to the lender. And the parties understand that the lender accepts the risk of default resulting from an economic downturn, so there's going to be no personal liability, while the borrower or the guarantor is personally obligated to protect the lender from certain other risks that the owner is in a better position to control or manage. So special kinds of personal guarantees are called carve-outs or exceptions to those non-recourse guarantees. Now, what is a guarantee? You might have learned this before, but a guarantee is a promise by one person, the guarantor or the surety, to answer for the debt, default, or miscarriage of another, the obligor principal, or to hypothecate the property for security. What are the requirements? I'm sure you remember these. It must be in writing, and it must be signed by the guarantor in order to satisfy the statute of fraud. Okay, the surety, though, is not necessarily entitled to ever receive a demand or an NOD from the lender because they are the surety, okay? They're not the borrower. Liability to the lender accrues upon default by the principal. So the fundamental rule of a surety obligation is that the surety can't be larger in amount or other respects more burdensome than that of the principal obligor. Now, a guarantor must be a separate person or entity from the obligor principal in order for that guarantee to be enforceable. So in other words, a corporation can't guarantee be the guarantor for a borrower, a single person borrower. Okay, with non-recourse loans in purchases or refi transactions, in theory, a lender is going to look only to the collateral in the event of default, i.e. no borrower personal liability. For these types of loans, borrowers and lenders prefer creating what you might have heard in the past as an SPE. It's a special purpose entity. And why? Well, because that structure is going to minimize the risk that the property could be consolidated into a bankruptcy resulting from other investments, and it reduces the number of competing creditors. Now, the definition of collateral in the loan docs is going to be very broad, and it includes all benefits pertinent to the property, such as the rents, the profits, insurance proceeds, and claims. Now, to protect against the risk, a lender is typically going to require that a related but independent person or entity form a limited guarantee or a carve-out guarantee. Now, that carve-out lists events such as a hazardous materials spill, a transfer of rental income from the SPE, waste, which is not paying taxes, fraud, misrepresentation, insolvency, bankruptcy, condemnation, that permit the lender to assert a personal cause of action against the guarantor, either for damages arising from the prohibited event or for the full outstanding balance of the loan. Failure to maintain a separate and a legal existence of the SPE can also trigger liability. Now, the guarantor is going to prefer a carve-out rather than a guarantee because there's no exposure to risk resulting from change in market conditions such as we've got now. The economic risk is borne by the lender as part of the non-recourse, but the guarantor's liability is limited to acts over which the borrower has some control. However, be warned, the courts, in most part, have ruled always in favor of the lenders. So, and they've rejected many legal arguments of the guarantors. Okay, to conclude, cases tell us that courts are prepared to hold guarantors liable for all damages to which the lender is entitled by the express terms of the guarantee. Understand that the borrower can create liability for the entire loan division. And in difficult economic situations, as we're going to be seeing, especially in the commercial markets, the parties will look to the attorneys, obviously attorneys, for guidance. But when negotiating a personal guarantee, understand that the guarantor's exposure, as there may be a difference between the actual harm to the lender, this is a legal term, approximately caused by the wrongful act, and the total damage claimed by the guarantee. Lastly, events over which the guarantor has no control may actually trigger carve-out liability. An involuntary bankruptcy, a hazardous waste spill, or other event could give a lender reason to declare a default. And when we see, as we are now, market values decreasing, a lender may treat these events much more seriously and pursue a claim against the guarantor. So the amount of the loss could be much larger than during a strong market because, and a claim for that personal liability would be much more attractive than a foreclosure action, just to keep in mind. So what have I talked about just a few minutes ago? I talked about a non-recourse loan. Okay, that's where the lender's looking to the property, okay, instead of to the borrower for the personal liability. Carve-out, a guarantor is going to want to carve out as much as he can out of that guarantee to protect himself against the liability back to the lender. And SDE, you're going to hear those words because over the last several years, a lot of lenders have required the borrower take title as a special purpose entity where they only, they own the property as Elm Street Partners LLC or Maple Street Partners